Hello there. Thank you so much for joining us. My name is Marcia Butler. I am the webinar director at Advice Chaser, and we're glad to have you here. As you're coming in the webinar room, I want to go ahead and go over our disclaimer, and then I'll tell you a little bit about how you can participate in our webinar today. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars, such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own, and however true, funny, or interesting, are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. We're thrilled to bring you today's educational event, and here are some tips for you as attendees to participate and ask questions. You are on mute, but we do encourage you to ask questions using the chat box, and the presenters will answer those queries during or after the webinar today as appropriate. If you ask a question in the chat box, go ahead and leave your phone number as well. And if we can't get to your question during today's event, we'll make sure someone reaches out to you afterwards. We want this experience to be as educational as possible, so please don't hesitate to ask for clarification or expansion of the material. I'd love to introduce you to our panelists today, and let me go ahead and put their pictures up. Our moderator today is Darcy Smoot, who is a principal with Nelson Capital. She has extensive experience in equity analysis and securities trading. Darcy graduated with a BA from Swarthmore College, majoring in mathematics and English literature. She began her career at Bloomberg LP in New York City, and in 2009 went to work as an equity derivative sales trader at Susquehanna International Group before joining Nelson Capital in 2014. Darcy is a chartered financial analyst and is a member of the CFA Society of San Francisco. And Darcy, why don't you go ahead and say hello so people can see your face, and then I'll introduce her. Yeah.
Sorry. Hi, everybody. Thank you. Thank you so much. I'm really excited to hear from Marissa. I've known her for years, but I'm really excited to hear her share her knowledge on this topic. I'm sure I'll be learning a lot alongside everyone else. So thank you, Marissa.
All right. And I'd love to introduce our presenter today. Marissa Sanfilippo is a certified family law specialist, a fellow of the American Academy of Matrimonial Lawyers, and a partner at Flicker, Karen Kruger, and Basada LLP. Ms. Sanfilippo has dedicated her entire career to family law and handles a wide variety of cases, including high conflict child custody cases and complex high asset financial matters. Prior to joining Flicker, Karen Kruger, and Basada LLP, Ms. Sanfilippo spent summers after her first and second years of law school with the firm as a law clerk, and upon graduation, she joined the firm as an associate and became a partner with the firm in 2016. Well, Marissa, we're glad to have you here, and I'm going to go ahead and turn over the time to you.
Thank you so much. I'm thrilled to be here and happy to be presenting with Darcy, who I have known for a very long time. So I hope that this presentation is informative. So our first topic is implications of divorce in a community property state. I'm sure a lot of you may know that California is a community property state, but don't necessarily know what that means. So what that means in California and a handful of other states across the US is that California differentiates between community property and separate property. Community property is typically everything that's acquired during your marriage, and during marriage, meaning from the date of marriage until the date of separation, which I will talk a little bit more about, with some exceptions. Assets that are inherited or received by gift are separate property, even if received during marriage. Assets that you may have had prior to your marriage that you have not commingled with your community property are also separate property. There are a bunch of fun exceptions and things that happen when people get married and sort of mix their finances, which we'll also be talking about, but those are kind of some of the general guidelines. The other thing I like to tell clients and potential clients is, as a community property state, California is actually pretty protective of separate property if you keep it separate. When clients come in and they are looking at potentially getting divorced, one of the first questions we'll ask is, are there any existing agreements? Is there a prenuptial agreement or a premarital agreement that was entered into before marriage? Is there an agreement that was entered into after marriage, a postmarital or a postnuptial agreement? Or is there any kind of transmutation agreement, which would be any agreement that changes the character of an asset? So for example, perhaps related to a residence. Part of the reason that we'll check for these agreements is it may change the default law if it's an agreement that's enforceable. If there is no agreement, then the California Family Code operates as your default agreement. You just don't know that when you get married. And that would govern the division of all of your property in a divorce. On to the date of separation, sort of what does that mean? It's one of the areas of the law that actually has changed a little bit in the time that I've been practicing, sort of comically so. We had a definition, we then changed that definition, and now we're back to that definition. What it means is it's an irremediable breakdown of your marriage. There has to be a subjective intent to end the marriage that has to be communicated to the other person. There needs to be some conduct consistent with that communication in order to have a date of separation. This is to avoid the kind of captain's paradise where somebody may come in years later and say, oh no, I told you I wanted a divorce, we were separated, but you continued to make all my meals, do all my laundry, we traveled together as a family, and we told no one that we were separating. That's the kind of thing that's not really going to support a date of separation. It's very, very fact specific. So if you are thinking about getting divorced, it's something that you would have to review with an attorney that you would be consulting with. And the impact is that it ends the community period, meaning that from the date of separation forward, earnings that are earned by a party are going to be separate property. Assets that are acquired after that date are also going to be separate property. So examples of where this can have an impact is if we have somebody who has equity compensation, maybe RSUs or stock options, from the date of separation forward, there's going to be a separate property interest in that equity compensation that continues to vest. In terms of the date of separation, in some cases, it makes a big financial difference. In other cases, it doesn't. And so part of that assessment is also, okay, if there's a dispute, how much are we really talking about here? It's an issue that I feel like people often commonly want to litigate because it's very emotionally charged, even if it may not necessarily have an enormous financial impact. So certainly something to examine with anybody that you're working with. The date of separation does impact how we would analyze the character of mixed assets. So for example, like equity compensation, we apply what's called a time rule based on a case called Marriage of Nelson, which ties in nicely to Darcy's firm, but has no relation.
No relation.
And basically, what we're looking at that point is, okay, if there was an equity grant made during marriage that's continuing to vest, the separate portion is going to get bigger over time. That community portion is going to get smaller. If there are new grants that are made post separation, those are going to be all separate property. So with the date of separation, we'll often use a time rule or some modification to that time rule in order to characterize different assets.
So is it generally considered the date of vest, if that vesting period happens after the date of separation, that vest amount is considered separate property?
It would be both. So with the formula, if it was granted during marriage and is vesting after, part of it's going to be community and part will be separate. And then the community portion will continue to go down. So the formula itself is a fun math equation, looking at the date of grant, the date of vest, and then the date of separation, and basically creating a fraction and then applying that to the future vests going forward. If you have something that was granted a couple years prior to separation, it's going to be mostly community property. If it was granted right before a separation, the community interest is going to be very minuscule.
That makes sense.
So implications of dividing assets. Darcy and I really wanted to highlight that it's emotional and financial. I have clients who are very attached to their primary residence, even if keeping it is a financial suicide mission. And so this is where I really bring in an advisor like Darcy, who could give some feedback on, okay, we know you want to keep the house. This is what that financial picture looks like. And this is why it does or does not make sense, or may make sense under certain conditions. Spousal support is something that used to have big tax implications, much less so now. At the federal level, it's non-taxable and non-deductible. That was a big change in tax law a couple of years ago. At the state level, it is still taxable and deductible, which is the default. Very often in cases, we will make it non-taxable and non-deductible, kind of all the way around, because it can be hard to remember when you're doing your California returns to handle spousal support differently. So certainly something to talk to an attorney about and your accountant in terms of what makes the most sense. Asset division in family law cases is tax-free under Internal Revenue Code 1041. That is the governing code section at the federal level. And there are similar state provisions that have adopted it. The one thing to remember is, and I am not a tax attorney, so I'm not giving tax advice, but it is important to make sure that both parties meet the citizenship and residency requirements to have tax-free exchanges. 1041 does not apply the same way to non-resident aliens and could create some tax issues if that's not something that's kind of on everybody's radar. IRC 1041 also has certain presumptions of tax-free transfers between spouses that do eventually time out. So if you're doing something like a really long deferred sale of a house where somebody is going to be in it for, let's say, 7 years while kids finish school, it's important to consider, okay, if then a buyout's going to happen in the future, how do you show the IRS, if needed, that this actually relates to a divorce that happened many years before? When we are looking at asset division, and this is something Darcy can speak to as well, looking at cost basis of what you're going to receive is really important. With 1041, cost basis doesn't change in these interspousal transactions, but you may be receiving an asset that has a lot of embedded tax, which is something important to keep in mind as you are trying to determine what your future post-divorce asset portfolio is going to look like. Darcy,
Right, exactly.
on that?
Yeah, and I think that's especially, you know, as it relates to a portfolio, I think that's kind of a great example, because if we're talking about one asset like a house, that's a little bit more of a, okay, we know what the house was purchased for, that's the cost basis, it's appreciated X amount, that's the gain that would be taxable. But when you're looking at a portfolio of assets, particularly, there might be an instance where there are retirement accounts that don't have, the gains are not taxable, but if there's a brokerage account or a trust account, for example, that is taxable, it's important to look not just at, you know, cutting right down the middle, you get these, you know, securities, you get these securities, but to look actually at the individual lots of each, you know, equity security or bond security to make sure that there isn't a lopsided attribution of gains to one person relative to the other. But I think, you know, understanding those embedded tax liabilities where there aren't tax liabilities in retirement accounts, for example, that's definitely very important to make sure that that's fair.
Agreed. So cash flow and budgeting is another reason why I will often want to work with an advisor in a case. I will sometimes have clients come in who have no idea what they've been spending during their marriage because they don't pay the bills. And then they're trying to recreate an expense summary as part of the paperwork that has to be done in California. To get divorced, you have to do a declaration of disclosure, a preliminary and a final. And an income and expense declaration is a piece of that, which includes an itemization of expenses that are either actual, estimated, or proposed needs. So trying to track those expenses is really important. Darcy, I think, can also talk a little bit more about kind of managing those larger one-time expenses one thing I want to point out, which is our fourth bullet point, which everybody's dying to know what an ATRO is. So when a petition is filed in California, a petition for divorce or legal separation as well, but I know we're specifically talking about divorce, there are financial automatic temporary restraining orders that go into place. They're all financial. So we're not talking about physical restraining orders. Every single one of them is financial, except for the very first one, which relates to taking minor children out of state, which we won't talk about today. The purpose of the ATROS is to keep the financial status quo, to prevent people from removing their spouse from health insurance policies, from auto insurance policies, from changing beneficiaries on retirement plans, from making extraordinary purchases without giving notice, from liquidating portfolios. So as you are managing larger one-time expenses, it's important to make sure if you are in the process of getting divorced or if you're thinking about it, because if you do a bunch of this, then you file a divorce petition the next day, the judge is not going to be super happy with you. So thinking about, okay, I do want to make this big purchase or whatever else, what kind of notice do I need to give? What kind of consent is required? Is an important part of this process.
Yeah, and I think in addition to that, like Marissa said, I think a lot of people might come into this, divorce situation, and as she mentioned, have no idea what they spend on a day-to-day basis. And I think, not only is it required or important to the divorce process, it's a great exercise as you might be, embarking on your journey as an independent, single person, to know what are those living expenses, because that is something that you'll have to manage. And as an advisor, that is the job of the advisor, to kind of understand what those ongoing living expenses are, breaking them into categories to know this is how much I spend on housing, food, clothing, travel, etc., on a monthly or annual basis. And then the other side of the equation is, of course, those sources of income. So understanding those two inputs is very important to building out a cash flow analysis to make sure that you have enough assets and income to sustain your living expenses. So it's definitely a good thing that it is required, and it's definitely something an advisor can help with.
And clients will often ask me, how do my expenses impact support? Do I just round everything up by 20% and then I get more support? It does not work that way. Temporary support is really temporary spousal and child support. We use a guideline computer program calculator. Typically, it's an apportionment of income. Expenses are relevant to permanent post-judgment, long-term spousal support. And so it is something that is considered, but it's not just a matter of you give me your wish list number and then I make the support number appear that would support that. It's really also finding a balance of, okay, this is what we think a realistic support picture looks like. These are your other expenses. How are you going to manage that gap going forward? And we're on considerations and expense management. And again, Darcy can speak to some of these as well, because this is the reason why I love to work with financial advisors on my cases. But certainly learning how to establish separate bank accounts and credit cards, establishing credit. I think Darcy and I have both had a lot of clients come in who have been authorized user on cards. They don't have credit, which can be scary. So I will always tell my clients, run your credit report, like at the very beginning of your case, figure out, do you have established credit? What's in your name? What are you only an authorized user on? What's on your report? And then work to build some credit. There are also expenses that can be layered in for your use of some of your community assets. And that is the Watts charges and the Epstein credits. So those are based on two cases. One of them was related to use of a refrigerator. It's a very old California case. They come up most often when somebody is occupying a family residence. So if you are in the family residence and your spouse has moved out, you generally, in many cases, would be expected to pay the costs associated with sort of servicing your residence. So the mortgage, the taxes, the insurance, et cetera. If those costs are really low and the rental value of your house is really high, your spouse could also maybe come back in the future and say, hey, you have use of this awesome community asset that we could actually make more money renting out. I want you to pay me some of the rental value on top of it. And those are the Watts charges. The Epstein credits are sort of the credit you get for servicing those debts. There are lots of reasons why these kinds of credits and charges are discretionary in cases. Things like child custody may impact whether or not a court would even consider those reimbursement claims. But something to think about as you're sort of analyzing, okay, should I stay in the house for the time being? Really being aware of what might that total cost to you look like, because it may be something beyond just the carrying costs. Darcy, anything you want to add on establishing new accounts?
Yeah, I think it just sort of, it's one of those things that might be obvious that, okay, I need to set up auto pay to manage those credit cards, but someone who's going through a divorce obviously has a lot of other things on their mind. So it's just a good reminder to anyone who's going through this process of establishing their own financial life, that they have to also kind of make sure that those pipelines between the credit cards and the monthly bills, the water gets paid, electricity gets paid. It's just kind of a reminder, I think. But definitely, as Marissa mentioned, the establishing credit is crucial.
Yeah, and the last thing I would add on the expense management, I will often, in cases that are high conflict, have parties who will kind of get into a standoff in terms of, well, I'm not in the house, I'm not paying the mortgage, well, you're not paying support, so I won't pay the mortgage. Don't let your assets go into default over arguments about expense reimbursements. At some point, just making sure that those bills are getting paid is an important part of your divorce to help preserve everybody's credit and those assets and everything else.
Yeah, that's a good point.
So on establishing relationships with your own professional team, I really work in a team approach. It's something that my firm has always really emphasized, and I think a lot of family law attorneys do as well. So if you are getting a divorce, obviously you have a family law attorney involved. On top of your own CPA, there may also be a forensic accountant involved to do things like the stock option apportion analysis. If there is a business that needs to be valued, things like that, but definitely getting that tax planning piece in there. An estate planning attorney is also a really important part of that team to sort of figure out that next step. When I exit out of a case, I'm really transitioning over to the estate planning attorney who's going to carry my client going forward. Once a divorce case ends, hopefully I'm not hearing from that client again, unless they're what I like to call a repeat offender with a second divorce later on, or they come back to me for a prenup. But really my time frame and any family law attorney's involvement with a client is sort of it's a much more limited period of time than the relationship you're going to have with an estate planning attorney going forward. So really important to get that in place. Insurance brokers, if you've got insurance to deal with, and then obviously also your wealth management team, which is that other sort of lifelong relationship I hope for a client, where I'm transitioning them off with the person who's going to carry their finances going forward.
Yeah, and I think just to add to what Marissa said, the financial advisor or wealth manager should really, I think, take the reins to help quarterback working with those other professionals. They may come in on the early side with the family law attorney to help understand what those expenses are and what those one-time larger expenses are. But on an ongoing basis, you want somebody who's going to work well with your CPA to find opportunities from a tax planning perspective, work with an estate planning attorney to think through the projected wealth situation and what tools might be helpful given that background and context. And then similarly, the insurance broker, just, making sure that there's appropriate insurance for home and auto, and specifically umbrella for larger estates. And also evaluating any life insurance that also can get back to an estate planning attorney if there should be something like an irrevocable life insurance trust, for example. So I think the financial advisor is really the one who should help you get that picture all together with those other professionals, is sort of my opinion. But I think the team approach works very well.
So tax planning, definitely something that's important in divorce. Most married people that I come across do file their tax returns jointly. And once your marital status is terminated, meaning you have a judgment dissolving your marital status, you can't do that anymore. So then it's a question of what is the filing status going to look like going forward. Head of household independency exemptions are a common thing we deal with. A lot of our clients share equal custody of their children. So then it's a question of Okay, do each of you have one extra day with one of your kids to meet that head of household requirement? Making sure that the custody agreement lines up with the way that you're planning to allocate those exemptions. If you're waiving dependency exemptions, making sure that those forms are ready and that there's a deadline to provide that 8332 form. I can't believe I'm about to recommend an IRS publication that's actually pretty readable, but publication 504 is, and it's something that a lot of family law attorneys and tax professionals will review. And I do think it's one of the more readable publications. So something that you can take a look at if there are questions about, okay, do I qualify for head of household? How do we waive a dependency exemption? What are the implications of taxes around this particular issue? There's a lot of good information in there. And Darcy, do you want to talk about some of the opportunities from a planning standpoint?
Yeah, definitely. We kind of alluded to this on the last slide, but I think the financial advisor should work with the CPA to understand in the new situation, the new financial situation, are there charitable giving opportunities? I guess this could apply for anybody, not just someone going through a divorce, but I mentioned this in the context of a divorce because it could be a dramatic change, whether dramatic change in income or marginal tax bracket, that could create an opportunity for something like a Roth conversion. It also, the other example might be managing large embedded taxable gains, or perhaps harvesting losses within the portfolio. So I think all of those are really important, and it is a good idea to get in front of a CPA and a financial advisor to see if there are new opportunities in your new situation.
And one other thing I'll add, if you are in a situation where you've got some income that needs to be reported on 2 separate tax returns. So for example, you've got some equity compensation, it's been divided. There are schedules and explanations that will need to be attached to each party's tax return to make sure that everything lines up. So being at a place where at least if you and your spouse can't communicate, your tax professionals can, to make sure that the information that you are providing to the IRS and the Franchise Tax Board is consistent. And finally, estate planning, my favorite questions from clients. Oh my gosh, are you also going to do my estate plan? No, because most family law attorneys do not specialize also in estate planning. But it's definitely an important thing to consider, I think, really right at the beginning when you embark on a divorce journey. Back to those ATROS and my fun acronym, there are certain things that you can do during the divorce process and certain things that you can't. So for example, you can create a new trust, but you can't put assets into it without a court order or written agreement. So just making sure with your family law attorney, if you're also doing estate planning, loop them in, introduce them to your estate planning attorney. Hey, we're working on a new trust. We're working on this. We're working on this. Are these things that are okay for me to do as part of that divorce process? Important things to consider once you're post-divorce, looking at updating beneficiaries on retirement accounts, life insurance, bank accounts, all of those various aspects, making sure that the assets that were assigned to you go to the places that you want them to in the event of your death after your divorce. Certainly creating a new estate plan, whether that's a new living trust or a new will. Also dealing with revoking your existing living trust. I have a lot of people who come in and want to do it right away. I always want to kind of confer with their estate planning attorney. Is this something that we should be doing now? Is this something that maybe we should wait on for certain reasons? So really important to kind of analyze the specifics in every case. Most people don't want their soon-to-be ex-spouse to continue to be their durable power of attorney. That's a change that you can and probably will want to make. And then also looking at your advanced healthcare directive, who is the person that you want making those medical decisions for you going forward, if it's not going to be your former spouse, which in most cases it's not. And on to health insurance, which I know Darcy can also speak to. Generally, there is COBRA available, meaning the opportunity to continue under your former spouse's insurance for a period generally of 36 months, unless if there's some sort of intervening employment termination, that time period may be adjusted, but generally the COBRA for divorce cases is longer than it is for just general cases of unemployment. One really important consideration is that the cost you pay on COBRA is the employer and the employee piece. It's not just the employee piece. So as you're planning budgeting, you look at your spouse or former spouse's pay stub and say, oh, great, the health insurance costs $50 a pay period. The COBRA cost is actually going to be significantly more. So working with your advisor to figure out, okay, does this make sense? Or do I want to go out onto the exchange and look at other plans available, which I know Darcy can speak to as well.
Yeah, I think that the exchange does have it. So here it's covered California, and there are a wide variety of options. I think which one is right for you is going to depend upon a lot of things. First of all, what is in the budget as far as expenses, but also how heavy a user are you of your healthcare insurance? I think that there are different plan options to consider kind of based on those inputs, high deductible healthcare plan, something like an HMO, like a Kaiser or a PPO. Again, there isn't a great answer of here's what you do. It really just, it depends. A lot of that is also, as you're choosing insurance outside of a divorce, do you want to keep the same doctor that you have? Is that really important to you? Or do you just want to be seen by anybody? So I think there's no wrong answer, but it is worth bouncing those ideas off of an advisor who can kind of help think through the cost benefit of those different plans. And then an HSA or a health savings account versus an FSA, which is a flexible savings account. These are two tools that allow you to put money away to be used in the future for healthcare, but they do have distinctions. The flexible savings account is money put away pre-tax, but it has to be essentially drained by the end of that calendar year. So that's if you don't use it, you lose it situation. Whereas an HSA plan it's essentially an account that rolls over. It's a separate investment account. Money can be put away pre-tax, invested and available to you when you do have those healthcare bills. So I think that if that's an option that is worth considering, that's definitely worth discussing with your advisor and your CPA, especially because there are those tax deductions that you can take to put that money in pre-tax.
And the HSA in particular is something you want to talk to your family law attorney about. Sometimes I have clients who have high deductible plans with HSAs and have blessedly had very low medical expenses. And so they may have tens of thousands of dollars accumulated in that account over time. So figuring out, is that going to be divided? Is there an agreement to just have one person use it for ongoing medical expenses for children? Just figuring that out and making sure that it's part of the financial disclosures.
Right.
All right, we're going to go ahead and open up for questions now. Darcy, I've sent you some of the questions that I've gathered here, and I'll just go ahead and let you get after those one.
Sure, yeah. So the first question here is, what if you live in a different state than your soon-to-be ex-spouse? So for example, my ex is in California, I'm not. Do you have to get divorced in California?
Good question. I love jurisdiction. It takes me back to law school. So jurisdiction is sort of where a case is going to be filed. There are considerations if you and your spouse live in different states. Some of it's going to depend on whether, at least for California, whether the state has personal jurisdiction in addition to having subject matter jurisdiction over your divorce. So I have cases where we have filed in California, even though my client's spouse lives elsewhere. Those are cases where I may try to personally serve that person in California because that's a way to perfect personal jurisdiction. I know I'm losing people here with the civil procedure. That's a way that can be done. And if my person's spouse doesn't otherwise have a lot of ties to California, I need to make sure that personal jurisdiction question is something that I'm analyzing. So sometimes it may depend on who files and serves the other person first. But in particular, if you're considering divorce and you're looking at two different states, consult with an attorney in the state that you live in, and maybe also consult with an attorney in the state that your spouse lives in, and have those attorneys maybe have a conversation. I've done that in cases where it's okay, this is what custody and the financial piece looks like here. This is what these pieces look like here. Like, where does it actually make sense for the case to start and finish?
Yeah, the takeaway that I got from that is ask your attorney.
Yes.
The next question we have here is, if I have been the stay-at-home parent, should I expect to maintain the same lifestyle if my ex-spouse can afford it?
This is another great question. The visual I like to use for clients is a pie. If you are taking the same pie, same pool of income, and you're now trying to replicate two households at the exact same standard, it's impossible. There are going to be a financial hit to both parties because there's just no way that you can replicate that standard of living. If your spouse's income is going up, or if a lot of your standard of living is savings, and your expenses are much less than your income, then it may be something that is more possible. It's going to be really fact specific depending on the income that is available, what the support picture looks like. But in general, particularly for clients living where I practice, because the cost of living is so high, it's very hard to sort of replicate two identical standards of living without a larger pool of income or a big cutting of expenses.
That makes sense. It's just even managing and having to pay for two households. That's a good visual.
Exactly.
Okay, the next question, if I have an amicable relationship with my soon-to-be ex-spouse, is there a way to do our divorce with mediation as opposed to using attorneys or whatever the opposite of mediation?
Yeah, I love mediation. I don't mediate personally, but I do a lot of mediation consulting, meaning that I have a client in mediation and I consult with them on the side. So most often when people mediate their cases, they're working with the mediator and their spouse directly. There may be, if I'm a consulting attorney, there may be a particularly sticky issue that they get stuck on, and the mediator may reach out to both consulting attorneys and say, hey, we've gone round and round on this issue. Can you both come to a meeting as well and help us kind of break the logjam? When you're in mediation, it's important to remember that the mediator does not represent either one of you. They can't give you legal advice. They can talk about what might generally happen or what might be a good fit for your family or what might not be, in terms of the options that you can consider, but they can't give you legal advice. So I tell my clients that it's also helpful to have your own consulting attorney. I know that adding a third attorney doesn't sound super cost effective, but it is, because your primary investment is with your mediator. My job as your consulting attorney, or the job of any consulting attorney, is to really give advice along the road to make it more specific to what suits your needs. But you are mediating your case with your spouse and really spending the most time and money with your mediator. I think mediation is awesome. The one thing I always tell my clients to consider is it is a lot of work, because all of the work that I'm normally doing in a case, you are now doing with your mediator and your spouse. You have homework you have to do. You might be having some difficult conversations. So definitely making sure that in addition to being amicable, you can dedicate the time necessary so that your case doesn't drag out longer than it needs to, because you and your spouse are both really busy and don't have the time that it would take to mediate. A lot of cases can be settled in just a couple of mediations. If you are mediating your case and you're on your 10th session, I think it's a good time to ask your mediator, how is this going? I have some cases that will finish up just in a handful of meetings, really like with a mediator who's organized, has a set agenda, gives you homework, and you come in prepared. Okay, next week we're talking about your house. Okay, great. Come in with your thoughts about what you want to do so that you're ready to make that process productive. But I think mediation is fantastic. I recommend it to most of my clients. Red flags where mediation may not be a great fit: substance abuse issues, cases with domestic violence, power imbalance. If you really don't trust your spouse, I don't know that mediating with them is going to be the best option, but those kinds of things, when I have people who come in and want to mediate, that's where I may push a little bit to explore, oh gosh, is this really going to be a good fit?
Yeah, that's a good point.
I just wanted to pipe in here. We did have a hand raised from one of our attendees, and I think I hadn't had the chat turned on. So I turned it on. If you can put your question in the chat, if you had a question, thank you.
I do have a couple more here. So the next question is, I'm worried I'm going to forget something in my divorce decree. We have 2 minor children. I know I have to think about college, but what about after school activities, car insurance when they turn 16, childcare, etc.?
Yeah, it can be hard to kind of make that laundry list. So when we set child support, we have the base child support and then bonus or additional child support, which is just the income. And then if there's a bonus or additional income, there's some percentage paid. Then we have add-ons, which in California are uninsured and unreimbursed medical expenses, agreed upon extracurricular activities, agreed upon educational expenses. The extracurricular activity piece is not specifically mentioned in the code, but is very often in there. Travel expenses for visitation, if you've got one parent who lives further away, and then childcare for employment. Those expenses are typically split 50-50 unless there's a really big difference between net spendable income of each party. That would more often be in a case where parties aren't married. So there's no spousal support. And so if child support is the only thing kind of equalizing income, it's a much lower percentage. As part of those add-ons, you and your spouse, if you agree, could add a laundry list of other things that you want to add in, like cell phones and insurance and gas and prom dresses and whatever else you want to. A lot of those things are otherwise kind of considered handled as overhead, which would be covered kind of by the base child support. But that's part of the important part of doing that expense analysis with your advisor. Somebody like Darcy can help prompt you to say, okay, look at your expenses. I think you're missing another couple of categories related to your teenage kid. Let's go through these. So I think that can be helpful, and then to help plan on how those will be shared going forward. College is not something that a court in California can mandate. Child support ends when a child is 18 and out of high school. So if your kiddo turns 18 and is still in high school, it'll go until they graduate or turn 19. There can be adult disabled child support in certain circumstances, which is its own ball of wax that I do not have time to present on today. But you can certainly agree to pay for college, and that can be a contractual obligation in your agreement. Definitely, I tell my clients, talk to your advisor about it first. If you are the person who's likely to pay for college anyway, that may be something that's worth doing. If your financial picture is going to allow you to either retire or pay for college, then obligating yourself in your divorce decree to do that may not be the best plan. So that's where I will refer my clients back to somebody like Darcy to say, is this an agreement that is worth putting in here, or is our shared client committing, a financial atrocity here for themselves in wanting to put their kid through college, which is such a noble goal, but a huge expense.
This is a great one. Can I require that my ex-spouse maintain life and disability insurance?
Yes. So we use life insurance as security for support very often. The question for either agreement or a court to determine is going to be who's going to pay for it. So a court may order life insurance as security for spousal support, for example. And in doing that, we would kind of come up with an estimate of what we think would be needed going forward. If you want a much larger policy and your spouse says, cool, knock yourself out, I'll go to a medical exam, but like you pay for it, then it'll become a question of who's going to do that. Disability insurance is another great thing to consider, particularly because my understanding of the statistics is that you are more likely to become disabled during your working career than die at a young age. We will have cases where we may work with a financial advisor to examine what disability insurance looks like to figure out if there is something that can be used to ensure that support continues to be paid going forward.
That makes sense. So I guess sort of similar, not really, sort of related, but what happens if my ex loses his job, for example? Does he still have to pay spousal and child support?
That's a great question. So he would need, or she would need, to file a motion with the court to say, hey, I've lost my job, I need to modify support. That is something that can often be worked out between parties and attorneys, unless there is some belief that that person is hiding income or quit their job out of spite. The court would likely grant a modification depending on the circumstances. And then there would need to be some analysis of, okay, what's the plan to return for work? So that order needs to be changed. I will have clients come in and say, hey, I lost my job, I'm just going to stop paying. And you can't do that. You have to file a motion so that you can get that order modified, or get a written agreement to modify it so that you know what that looks like going forward.
And then what about moving out of the state or out of the area? I'm not able to work and afford housing in the area where I currently live, but I'm worried my spouse won't let me take the kids out of their schools. How is that handled?
Right, so that becomes a relocation, which I could probably give like an 8-hour presentation on. It's very fact specific. If you want to look up the factors that are most frequently considered by the court, the leading case on it is Lamusga. It's LAMUSGA. And that goes through the analysis of the relocation factors. Part of what a court's going to look at is, do the parents share joint custody already? Does one parent have sole custody, which may change some of the presumptions about moving? And then they're going to make a decision, not whether or not you can move, but where your child or children should live when you do. So the correct legal analysis is for the court to assume that you are going to go wherever you say you will go. And then the question is, do your kids go with you or do they stay with your spouse? Relocations are some of the hardest work that I do as a family law attorney, because you can't really split the difference. It's not, I want to move to Boston, you want to stay here, and we are going to settle on living in Chicago because it's in the middle. Something's just going to happen. And it's very difficult because there are typically factors that weigh in both directions. I don't often have those relocations that are just such an easy piece of cake, because those ones often resolve on their own. So factors that a court's going to consider, it's not just, I can't afford to live here. I do wish that that was something that was taken into greater consideration, but it's not. It's the relationship between the parents, who's more encouraging of the other parent's relationship with the kids, how established are the kids in the community, what does the current timeshare look like, what's the reason for the move, do you have a good reason, are you just being spiteful? Things like that are part of the analysis. And if there are financial resources available, there would probably be a custody evaluation in which a mental health professional would take a look at all of those factors and make a recommendation to a court on what a schedule should look like when this parent relocates. Sorry, it's one of those lawyer answer, non-answer to a question, because it depends.
No, it's a very good, that's a complicated question. Last one, or I think this is the last question, but can you talk about QDROs or quadros?
Yeah, so quadros is a qualified domestic relations order. There can also be a DRO, which is a domestic relation order that's not qualified. We use those to divide retirement plans. So for example, if your spouse has a 401k and the 401k is the only plan, we would use a qualified domestic relations order to figure out what amount of money or what portion of that plan should be provided to you to equalize it. I most often use joint experts for this task. There are several people throughout the state of California who all they do is retirement account divisions. They love the work, which I think is great. People wonder how I do what I do for a living. Sometimes I've asked them that question, but they're experts in that area. And so what they would do, for example, I also will have clients who have 15 retirement plans. Well, it's not super cost effective to do a separate quadro to divide every single plan. So they may do some math and say, okay, here's the total community interest. This is the plan we're looking at the rollover from. This is how I'm going to prepare the quadro, et cetera. Also really important to kind of start that process early. Once you have a judgment of dissolution entered, if you haven't joined certain pensions like CalSTRS, or you don't have an order dividing it, it can create huge problems later. So really important to make sure that you work with your family law attorney up front to figure out, okay, here are the plans. Are there any pensions that need to be joined? And then who are we going to hire and how are we going to get the quadros done to make sure that the retirement account division happens? Similarly, sometimes when it's left to the end, it can be forgotten. I have had referrals from potential clients who I did not represent in their divorce come in and say, we never did our quadro. It's been 10 years. So make sure that that's done as part of your divorce process so that you don't have to come back and deal with it after the fact. But that's what quadro stands for. It's really the retirement account division order. They can also be done for things like pensions, where you're going to get that payment in the future, but making sure that it's coming directly to you and figuring out what your portion should be, very heavily impacted by the date of separation. Contributions that are going in post-separation are someone's separate property. And so typically there needs to be some allocation of, okay, we've been separated for 9 months. We're finally dividing this plan. This piece is my separate. This is the community.
Well, that's about all the time we have for questions. I'm sure, Marissa, you could talk about this for the rest of the day. I love your passion. And it's good to know that there are people out there who want the best for you. And hopefully, if you're going through this, You can find some really awesome people to help you with this. So I want to thank our presenters for being here today and also for the organizations that have made this webinar possible. Look to an email soon with a link to the replay of this event, and you're welcome to share that replay with friends or family or any other interested party who might want to learn about this topic. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for your life and your financial questions. Our matching service is free to you, and every one of our advisor partners has committed to offer a free initial consultation to anyone we introduce them to. Find out more by going to advicechaser.com and clicking on the link to find an advisor. Well, once again, from Advice Chaser, thank you so much for coming, and we'll see you at another webinar soon. Goodbye, everyone.